What to do when a brand dispute triggers trademark litigation in Oklahoma. When a brand dispute escalates past a cease and desist letter, it enters the arena of federal trademark litigation. Under the Federal Lanham Act, a trademark registration gives you a powerful asset, but it is not a blank check to shut down other businesses. If you take a competitor to court for trademark infringement, the burden of proof rests squarely on your shoulders. Winning a lawsuit requires demonstrating a clear, legally defined set of elements to prove your brand identity has been unlawfully compromised. The core elements of an infringement claim. To prevail in a federal trademark infringement lawsuit, a plaintiff must establish three primary elements. Ownership. The plaintiff owns a valid, legally protectable trademark.
Priority. The plaintiff used the mark in commerce before the defendant began using their version, being the senior user.
Likelihood of confusion. The defendant's use of a similar mark in commerce is likely to cause consumers to be confused about the source, origin, sponsorship, or affiliation of the goods or services. While proving ownership and priority is often a matter of producing a certificate from the U.S. Patent and Trademark Office, USPTO, or proving local operational history, the entire battlefield of trademark litigation usually concentrates on the third element, the likelihood of confusion. How courts evaluate likelihood of confusion. Courts do not simply eye-test two logos and make a gut decision. Instead, federal circuits look at a specific set of non-exclusive factors to analyze consumer perception. In our jurisdiction, the 10th Circuit, judges weigh 6 distinct factors to decide if a consumer is likely to be confused.
1. The degree of similarity between the marks.
This looks beyond exact duplication.
Courts examine the marks side by side and out in the real world, analyzing cite. Do the logos, fonts, or colors look alike?
Sound. Are the names pronounced similarly? Meaning, do they evoke the same mental imagery or commercial impression? 2. The strength of the plaintiff's mark. Not all trademarks are created equal. The law categorizes trademarks on a spectrum of distinctiveness. The stronger a mark is, the wider the scope of protection a court will grant it. Fanciful, arbitrary, strongest. Invented words, like Exxon, or common words used in entirely unrelated contexts, like Apple for computers. Suggestive, strong. Words that hint at a product's function without explicitly stating it, like Netflix for streaming. Descriptive, weak. Words that directly describe the service, like the ice cream shop. These only get protection if you prove secondary meaning, that local consumers uniquely associate that generic phrase with your specific business. 3. The intent of the alleged infringer. Did the competitor intentionally copy your branding to ride your coattails and cash in on your established goodwill? Sometimes, a cease and desist letter can head off potential litigation. When a plaintiff can prove the defendant acted in bad faith to intentionally deceive the public, courts are far more likely to find infringement and potentially award triple damages or attorney's fees. 4. Market proximity. Goods, services, and marketing strategies. Do the two companies actually compete for the same clients? If two businesses use a similar name, but one sells heavy construction equipment in Oklahoma, and the other operates a boutique bakery in Vermont, confusion is highly unlikely. Courts look at whether the products are sold in the same geographic areas, via the same channels, e.g., online versus brick and mortar, and to the same target demographics. 5. The degree of care exercised by consumers. The sophistication of the buyer matters immensely. When consumers purchase inexpensive, everyday items, like a soft drink or a t-shirt, they exercise a low degree of care and are easily confused by look-alike brands. However, if the dispute involves expensive B2B software, medical equipment, or professional legal services, courts assume the buyer will perform extensive due diligence, making real-world confusion much less likely. 6. Evidence of actual confusion. While you do not have to prove that a customer actually got confused to win, showing real-world evidence is considered the holy grail of an infringement case. This is typically proven through logs of misdirected customer service phone calls, emails, or negative online reviews meant for the competitor. Rigorous, scientifically designed consumer surveys conducted by testifying expert witnesses. Note on anecdotes. Federal courts have consistently ruled that isolated, passing instances of confusion, like a single mistaken phone call, are considered mere anecdotes and may be disregarded. A plaintiff must demonstrate a patterns or substantial risk of widespread confusion. What is at stake in trademark litigation? Trademark lawsuits are high-stakes endeavors. If an infringement claim succeeds, the court can issue several severe remedies against the losing party. Permanent injunctions, a court order forcing the defendant to immediately halt all use of the name or logo, pull down websites, and completely rebrand their business. Monetary damages, forcing the infringer to pay the plaintiff for lost profits or hand over all profits earned while utilizing the deceptive mark. Destruction of goods, ordering the literal destruction of all infringing labels, signs, packaging, and promotional materials. Because a loss can force an established business to discard its entire marketing history overnight, litigation requires an aggressive, data-driven approach from the very first filing.
Oklahoma trademark litigation attorneys in your corner. You've spent your firm's time and money to create a brand that reflects the special attributes of your brand.
When another firm infringes on your product, protecting your brand from dilution is important not just today but in the future.
For a free consultation with an Oklahoma business law attorney at Kania Law Office, call 918-743-2233.